Guys, those are the consequences of using trial versions. I know that I just saw that Daniel warned me that we have 1 minute left, and I didn't do that because I talk a lot to a point where I do not notice such things. I do apologize for that. Thank you for notifying me, Mr. Daniel. Do we have Dr. Kenzani back? Let's see if she's here. She is not here yet. She was trying to explain a very important issue. Okay, I'm gonna mute. And do we now have Dr. Kenzani back?
Yes, I am back, and I believe I've missed a lot because
no. It was we were all cut off. So you please continue from where you left. Dr. Kenzani, do you want to go for it? Can you guys hear me?
Yes, but she's muted. Tell her to unmute yourself.
Dr. Kenzani, do you want to unmute yourself? Okay, maybe she has load shedding, but let's move on. I'm trying to get the question back. I know it was a question of surrogacy and the contract. Does anyone wants to give it a try? The validity of that contract? Oh yeah, I can see. Oh, she's connected now. Dr. Kenzani, do you want to continue where you left off with the validity of that surrogate agreement?
Yes, please. I had just said, because in South Africa, the way I understand it, surrogatehood is not done for monetary value.
Yeah.
You don't get paid for that, so it's not a good. It's not the right one. Moreover, it's not the blood relation. They are not bloodly related.
Yeah.
Blood related, yes.
Okay, that is correct, Dr. Kenzani, because as soon as there is a payment, the contract becomes invalid. So what would happen? I just want to throw this. You guys can explain the way that you want to explain, but I just want to throw this. However, sometimes the court does allow that the couple that is trying to have a baby, that they can take care of the expenses of this woman that is helping them. Like whenever she needs to go to hospital, they're the one who takes care of those expenses and so on and so on. So yeah, I am happy with that. If we are all happy, we can move on.
Sorry, T.
Yes,
I was cut off network when Dr. Kenzani was explaining.
Okay.
If she can repeat herself.
So what she said was that the surrogate agreement in in fact, if you want to be a surrogate in South Africa, you cannot try and make it your income. You cannot get money from it. So as soon as you demand payment, then the contract becomes invalid. It's not allowed. It's against the law. Is that okay? Are you happy with that, Sylvia?
Yes, thank you so much, Dee.
Okay, thank you. Oh, yes?
Okay, like I said, I'm done with my assignment, and while I was answering that question too, I don't know exactly which part. I had the issue of agreement. Is surrogate agreement supposed to be sent to somebody through mail and they just fill and send it back to the couple, or is it supposed to be completed in the presence of the judiciary officer at court?
Not necessarily in court, but you can obviously, I would assume that this couple, I don't know who their names are. I would assume that this couple, they are not legal practitioners. Remember, if you're not a legal practitioner or an officer of the court, you cannot draft any contract. So a contract to be valid, it has to be drafted by a legal practitioner or an officer of the court. So I would assume that these people, these rich people that want a baby, they have obviously approached a lawyer, and then they've drafted this contract, and then this contract has been sent. I know it's not clear on here, but the contract has to be drafted by a legal practitioner or the officer of the court.
But the signatory part, can I just sign, let me say you are in what, KwaZulu-Natal or what that place, and then the other person is somewhere in Pretoria. Can you just send the contract and the person sign their side, or you need to be together then in presence of somebody from court, you sign the contract? Because otherwise she will sign the contract, then whenever they are going to involve now the lawyer and explain to her more, because the time, if you send it to her, she will obviously sign without explanation, but her intentions are wrong.
Yeah, no, I do understand your point, but remember, when it comes to contract, obviously she can dispute it along the way or 5 years down the line and say, I didn't understand the contents of the contract if it was not explained to her. But according to South African law, the contracts are supposed to be in the legal document, especially the ones that are sent to lay people. They're supposed to be in a language that is simple, in a language that a lay person can understand. And also, that particular person, they're supposed to, the contract is supposed to be explained to them in a way that they understand all the terms. So I know that this is it's a very big argument that we can talk all night about it. But how about when I applied for such a thing at the bank, they only highlighted certain points. Yes, they violated your right, but a contract is supposed to be in a simple and understandable terms. So in that particular manner, it can be rebuttable at a later stage when the lady says, I didn't understand the contents of the contract. But if she didn't understand, she could have asked as well. But the bottom line is that you don't have to be at the same place in order for the contract to be valid. You can sign the contract. You can even digitally sign it. That contract will remain valid. So it doesn't matter where they are, as long as they have made their intentions clear, and everyone is of an age that they are able to understand and they're able to distinguish between right and wrong.
Okay, it's clear.
Yeah. Okay. Yeah, if there's no other question, we're gonna move on to 2.2. Daniel is 16 years old and the plaintiff in the legal proceedings. He wants to know in which circumstances can a curator ad litem be appointed for a minor in legal proceedings. He wants to know in which circumstances can a curator ad litem be appointed for a minor in legal proceedings. Do you guys still remember what a curator ad litem is? I don't know if you guys still remember this, those who attended the session where we spoke about, it was status. I spoke about the curators. I spoke about the curators. It was a curator personae, it was a curator ad litem, and it was a curator bonus. And I explained how the duties of those curators and who appoints those curators and for what reason. Do you guys remember at least the topics for curator? So a curator is somebody that is appointed by the court in cases where in cases where that particular person does not understand. So let's talk about the curator ad litem. A curator ad litem is appointed in circumstances where a minor, in this instance, does not understand the terms of the legal proceedings. So at this stage, this curator, because remember, this 16-year-old Danny, he does not have capacity to litigate. Do you guys remember that? Hi, you guys, you don't go back to watch those videos again.
Yes, we do remember.
Okay, so the curator ad litem is, I don't even remember what the question says. He wants to know in which circumstances can a curator ad litem be appointed for a minor in legal proceedings. So a curator ad litem is appointed for a person who does not understand the legal proceedings or who does not have the capacity to litigate due to their age, their mental capacity. I don't remember the other one. I mentioned it. I mentioned it previously. So if you guys do remember that, then which means your answer lies there.
Is that the answers? Maybe I have to go and look for my documents.
Yeah, you have to go and look for it, and then you will find it. You will find on that session, it's on the capacity to litigate.
Because I thought it's when the parent, like the guardian, cannot be found, or those things.
No. If the 16-year-old is in a party to a lawsuit, the parent or the guardian cannot litigate on their behalf.
Okay, I'm out. I'm going to look for my books.
Hi, T.
Yes.
Just a question from my side. So, Roman, it's the first time I'm joining the session with you.
Not
You
a
did
problem.
highlight that there are certain videos that you shared with the guys. Is it something that you shared via WhatsApp or through a different?
So I
platform?
posted a link on the on the WhatsApp. I can still post the link to
I'll appreciate that, man.
I'll post
appreciate
the
that.
link there, and then you can go and watch the video, specifically the ones for law persons. And I think it's on status. And it looks like DK is on top of things. Well, he is always on top of things. So he says it's question 2.2. It's on page 140 of the textbook. So if you have the textbook, you can go and read it from there. Okay, let's move on. Let's move on to the next question. The next question is, T is a 9-year-old extramarital child. Oh my God, why me? Her mother lives in Mamelodi and her father in Durban. Her mother lives in Mamelodi and her father in Durban. Also, T is a girl. T lives with her father, where T is domiciled. Discuss briefly and refer to relevant authority. T is a 9-year-old extramarital child. Her mother lives in Mamelodi and her father in Durban. T lives with her father. Where is T domiciled? Oh, okay, perfect. So it's a question of domicile. I discussed this. It was a session. I don't know if I recorded that session by myself, but I think it's one of the last sessions that I recorded on domicile. Does anyone wants to take that? Oh, there we go. But I did. But you're going to have to, that is correct, Janice. So there is the answer. It has been given away. But you will have to substantiate why are you saying that T is domiciled where you say that she is domiciled. in order to be able to substantiate that, you have to understand what domicile is and the requirements for domicile. But the answer has been given away, and there is a session that I did. It's named domicile. Did you guys see it?
Yes, Steve, thank you very much.
Okay, all right. So that is a five-mark question. So you can discuss it, or maybe give like you can say yes by her father, and so on and so on, and then you can just discuss the maybe the requirements of domicile, and why is it that she is domiciled by her father's place. I did explain that in detail, so you can find that answer on that video. I really don't want a lawsuit from Stadio for discussing all the answers, but I've already broken the rules. I might as well continue. They say it's easier to ask for forgiveness than to ask for permission. So let's go to question 3. As an expectant mother was injured in a motor vehicle accident, her child was subsequently born with cerebral palsy. Due to brain damage, the child will never be able to take care of herself. The accident was caused by the sole negligence of the other motor vehicle. Write an essay in which you discuss Naskatura's fiction. Marks will be awarded in the following manner: short introduction, facts of the relevant case, legal question, issues addressed by the court, judgment, reasons for the judgment, and good academic writing. I would assume that you have already done so. And the case, who wants to give it away? That's a very famous case. I will give you a couple of cases, and then you can choose. We also discussed this. I think it was our very first session, the very first session number 1 that I did with you guys. I did give you the cases. I said you guys can go ahead and download these cases and then read those cases. And remember, in your legal career, these cases will come popping up because they are famous cases, and they're cases that have groundbreaking judgment. So the first case will be Pinchin versus Santam Insurance. You guys, I'm sure you remember that case. I am not going to go into detail with that within that case, but that is the case that is relevant to that particular question. So do you want me to type it for you if you didn't write that question? But it is.
Yeah, can you just repeat? You said what's the plaintiff on that case?
It's Pinchin versus Santam Insurance.
Okay.
It's not the Mtati case.
No, it's not the Mtati case. The Mtati case, I have the Mtati case. The Mtati case was not cerebral palsy. The one that was born with cerebral palsy is the Pinchin case. He was born with cerebral palsy and brain damage. Yes, I am right. The one in Mtati case, the child suffered brain damage and was mentally disabled. So do not confuse the two. So the Pinchin case, the child was born with cerebral palsy and brain damage. Are we happy with that one?
No, I'm totally confused. Can I just engage here?
Yeah.
So what you're saying is with the introduction, right? We need to explain the case, right?
Let me see what the question says. Okay. Have you guys, do you know anything about FIRAC?
Can you repeat the question, Tim?
Do you know something called FIRAC?
I don't know.
No.
It's the facts,
No.
issue, reasoning. This is for you when you are reading the case, not when you're answering this question. Facts, issue, reasoning, application, and conclusion. So if you use this, hi Njabulo, if you use this, you will be able to break down that, you'll be able to easily understand the case. So you download the case and then you scan through the facts. And the facts of the case would be something like this woman, I don't know what her name was, this woman was pregnant. That is a fact that cannot be disputed, right? And then this woman was injured. That is a fact, and that cannot be disputed. And then you look for all the facts, and then you go to the issue. When you're talking about the issue, you're looking at the problem. What was the problem? Why was this case? Why do we have this case? You look at the issues that they are facing, and then the issue here. So the facts already, once you get all the facts, once you get all the facts, and then you can go to the issue. But once you know that you have now all your facts, then that answers the first, the second part of your question, the one that has correct. Oh, don't put in both cases. Please do not use both cases, because the Mtati case is not a case for cerebral palsy. It was brain damage and it was disability. And then the Pinchin case, it specifically says cerebral palsy. And your question in this assignment, it explicitly talks about cerebral palsy. So please do not confuse the two. You're going to lose your marks because you're going to be showing knowledge that you do not understand the question, or you are not sure which case is it. Okay, so let's go back. So, and then you go to the, so after the facts, you will see, I said issue, and then the, on your book here, on your assignment, it says legal question, issues addressed by the court. So that is the issue as to why we have this case. Why did she approach the court? So we'll see that the issue now is that the issue is that the woman lost a lot of amniotic fluid, but the birth process was proceeded as normal. But when the baby was 4 months old, now this is the issue. He was diagnosed with cerebral palsy and brain damage. That is the issue, and that is the reason why this whole matter is in court. So please, when you're analyzing cases, you must use that method. It's going to make it very, very easy for you. And then with regards to the reasoning, is the reasoning for the judgment. That is the second part. So when you download that case, you will see the judgment of the court would be listed there. I'm not too sure if it's listed in a textbook. It should be. So the judgment will be listed there. It's 2 marks. Don't go crazy about it or start writing a lot. You can write something that is worth 2 marks, and then the reasons for the judgment. So the reasons for the judgment is the statements that the judges make before they make the final decision. So in most cases, they usually look at judicial precedent. On this particular case, I am not so sure which case they looked at, because I think the Mtati case was after that. I'm not so sure, but it will be there on that case. And then obviously the good academic writing. So what I can say, because this assignment is due on the 26th. So what you can do is that you can go and download the case if you haven't already done so. Go and download the case, go through it, analyze it, lay down your facts, lay down the issues that contribute to your answers, the judgment, maybe in two bullet points, and then the reason for the court for that particular judgment, and then you list it in bullet points or however way you prefer to write, and then you can send it to me if you are unsure. There is no, you don't have to send it to me, but if you still feel that you are unsure, you can still send it to me. I will only be able to respond on Saturday. So I hope that we are fine with that. Does anyone has a question? Guys, I talk too much. Yo.
Just a comment, I'm back. I went to look for my proof when I was disputing that what you mentioned earlier is not the right thing about the minor, appointing a curator ad litem for a minor.
Yeah.
Because the one I got there, 1, 2, 3, 4, 5 reasons.
Yes. Do you want to read those reasons for us, or do you want to read it
Yes,
at the end of the
yes, I want to
session?
read the reason for you, and then maybe you guys comment that I'm wrong. Or
Okay,
maybe
what do they
correct.
say?
They say capacity to litigate, and that is 8.3. Sometimes it might be necessary for the court to appoint a curator ad litem to represent a minor in legal proceedings. Traditionally, a curator ad litem is appointed in the following circumstances: when the minor has not, when a minor has no guardian, or the guardian cannot be found, or the guardian unreasonably refused to assist the minor, the interests of the minor are in conflict with those of the parent, or the litigation against the guardian.
Yeah, that is absolutely correct.
Yeah, so it's I don't have what
You can just type it on the chat box for everyone to see.
I'm also not familiar. Let me try.
Okay. All right. Can we move on to the next
And
one?
I had a question where we came from now. Are we going to specifically use one case study only for Pichini and Santam, or we are going to incorporate other cases? Because if you look at this Pichini and the Santam insurance company, it's like its earlier case, but somehow it's like disputed by the guys like Jobet and others who felt like it's not fair for us to claim how do I put it?
I don't think, I think if you start reading the commentary for Jobet and Van der Vyver, you're going to confuse yourself. At this particular case, that is the only case that where a child was born with cerebral palsy.
But is your South African law still using the same judgment or
no,
reason for judgment?
It was over, if I am not wrong, it was overturned by the Mtati case.
Yes, because the other one say you have to use the law of delicit, which have I think 6 or 5 legal requirements. Then you check which one he was affected.
Yeah, but I don't want you to miss the point and reference a case that is not the one that is relevant to your question. The one that is relevant to your question is for this particular one, where a child is born with cerebral palsy.
All right.
Yeah.
Thank you.
Do not confuse it with the one for Mtati, because as much as the one for Mtati is still, it talks about Nasca Chura's fiction, but it is a different case because the facts of this case are different. In fact, the issues are different.
All right.
Yeah. Okay, guys, prenatal. Yeah, guys, do you guys want to move on? I'm looking at the time. I'm wondering if we're gonna have time for the second session, but yeah, we'll see as we progress. Do you guys still have any questions? Can we move on to question 4?
Yes, please move on.
Okay, let's go to question 4. Juju is very interested in politics. Juju gets involved with the Freedom Party and lives his dream. That Julius. Jacob, as president of the Freedom Party, requests Juju whether he will be interested to become a member of parliament. Juju is very interested and hopes that his dreams in politics will materialize. Juju was declared insolvent 3 years ago and needs your advice. Advise Juju in totality regarding the legal capacity of insolvents and briefly the process to be followed to become solvent once again. So this is it's insolvency. So we do know that insolvency it does have an effect on legal capacity, and we also know that the insolvency has an effect on capacity to litigate. So how would you, we have less than 10 minutes again. Ooh. Could have started earlier. Okay. Where's that question again? So the question is, Juju was declared insolvent 3 years ago and needs your advice. So now you're advising Juju regarding the legal capacity of insolvents. Let's start from there. What is Juju's legal capacity right here? Because now we know that Juju is insolvent. I know we didn't discuss this, but anybody who have who went on to read. Okay. So there is something called Insolvency Act, right? So I'm not sure if I'm going to start there. Okay. A sequestration order results in the insolvent losing control of his or her estate, but does not, as a rule, affect his or her capacity to act. This simply means that the solvent can, with certain exceptions, perform any legal act. He or she may dispose of any assets of the insolvent estate. So there is a case of Umzinyati Municipality versus Transglobe Industrial Holdings. The court confirmed that if an application is brought to declare a person insolvent, a successful counter application would have the effect of the respondent being declared solvent. The Insolvency Act also provides for certain contracts that can only be concluded with the consent of the insolvency curator. Contracts are likely to have an adverse or seemingly adverse effect on the insolvency case, and contracts have any relation to business of a general dealer or manufacturer. Okay, the effect of insolvency on capacity to litigate. Let's. I will type the case for you, Gavin. It's Umzinyati. It's not really. You obviously don't need to know that case because it's not relevant to the question. Umzinyati District Municipality versus Transglobe. I type very slowly, guys. So I'm supposed to be a lawyer. I'm not supposed to be typing. I'm grooming myself to be a lawyer so that I can have assistants that can type for me. Transglobe Industrial Holdings. There you go. There is the case. I don't know where I was. I was talking about the effect of insolvency on capacity to litigate. According to Section 23(6) of the Insolvency Act, I'm not too sure if anyone has a textbook, please just make a note of that. I'm just going to go through what I have here. We need more information on question 3. What information do you need, Janice? On question.
IT You can continue. I'll speak to you offline about question 3. Thank
Okay.
you.
Okay, no
I
problem.
wanted to. Thank you, sir.
Okay, cool. So according to section 23(6) of the Insolvency Act, all proceedings against an insolvent estate are stayed. It is irrelevant whether the proceedings were instituted by or against the insolvent. The Act, however, in section 23, subsection 6, make express provision for certain circumstances in which the insolvent will retain his or her capacity to litigate. In such cases should include cases in which the dispute has an effect on the insolvent status or any right which does not affect the insolvent estate. Actions concerning defamation or personal injury. Cases in which the dispute arises from a juristic act into which the insolvent was competent to enter. Actions to recover pension to which the insolvent is entitled. So let's talk about the effect on the insolvent's legal capacity, because I see that's where the question is. What does it say again? Capacity of insolvents. Okay, cool. So the capacity, a person's legal capacity is influenced by a declaration of insolvency. So after the declaration of insolvency, what's his name? Juju's legal capacity is already affected. While an insolvent may follow any profession or occupation, he or she may not carry on a business of a general dealer, a manufacturer, or be employed or have an interest in such a business. The insolvent may also not hold certain offices. He or she may, for example, not be a curator of an insolvent estate or hold a liquor license, and may only act as the director of a company with permission from the High Court. That is the end. Do you think your answer lies there?
Correct. T.
Okay.
Thank you.
Okay. So that was insolvency. Anyone has a question? Should we go back to the source? Okay. Let's go to, we have 2 minutes and 22 seconds. I'm also thinking in my head, how are we gonna make this easier and faster, actually? Question 5. V is a citizen of Malawi. Oh, okay. So sorry, guys. Question 4, it also says, briefly explain the process followed to become solvent again. So that is explained on the first paragraph that I read. I don't know if you guys took some notes. I'm not gonna go back there again. We can have a chat regarding that. So we're just gonna move on to the next question. And so what I'm going to do is that we will try and I want to say ISL nabe LFL ngathi soxabana namhlanje. But anyway, we have another minute left. We'll see how we're going to utilize that. V is a citizen of Malawi and is an illegal immigrant in South Africa. He has lived and worked in Sunnyside for the past 2 years. He wants to acquire a domicile of choice in Sunnyside. What effect does V status as an illegal immigrant have on his capacity to acquire domicile of choice in Sunnyside? Advise him. So, did you guys watch the domicile video? I have less than a minute. Let me stop this session and then I'll come back immediately. So you use the same link, then we can continue with this question. See you guys shortly.
Yeah. You've recorded the session, right?
Yes, but it's not supposed to